Ms. Stanziano, I want to ask this question, ma'am. Are you impaired today on something? Are you under the influence of narcotics here today?
No.
You oftentimes hear judges ask that question, but it's usually to a criminal defendant in a courtroom, not one of the attorneys. Unbelievable story out of Kentucky. Conroy DeLuce from our affiliate WLEX has more for us tonight.
What was the other issue?
I'm sorry, Your Honor.
On March 9th, with Judge Samuel Spalding presiding, court was set to begin in Greene County. But before the jury was brought into the circuit courtroom, Judge Spalding asked the attorney for the defendant, Bethany Stanziano, a question.
Ms. Stanziano, I want to ask this question, ma'am. Are you impaired today on something? Are you under the influence of narcotics here today?
No, not, Your Honor.
The proceedings continued and a jury was brought into the courtroom. However, minutes later, when asked by a judge, Stanziano said she was not ready to proceed. After the judge asked why, this exchange occurred.
I'm trying to think. Yes, probably just a couple brief statements, but probably need to be put on the record.
Okay. All right, ladies and gentlemen, I hate to do this.
The judge and attorneys then left the jury, continuing discussions on another floor.
Okay, we're on the record, back on the record.
The attention turned away from the case to the state of Stanziano.
I can't focus because the pain in my feet and the right leg from the knee down is excruciating.
She maintained that she was not under the influence, but was on medications due to neurological issues. However, the judge said that her medical documents submitted before trial did not support the state of pain that she claimed. In a court order, Judge Spalding cited Stanziano's speech, demeanor, and appearance for asking for a drug test, which she eventually refused.
And you've assured me that you are clean and that these drug screens would be negative. Therefore, there should not be an issue with you taking it. And if you're not, ma'am, I'm going to have to take action here.
Your Honor, I would like to speak with my attorney.
Okay, she's remanded into custody.
1 minute later, sheriff's deputies pushed her wheelchair out of the courtroom. She was taken to the Taylor County Detention Center. 2 days later, on Friday, March 11th, the judge wrote a new order stating that he had been advised that Stanziano would comply with the drug screen order, and if she submitted a hair and urine sample for testing, she would immediately be released from jail. Officials at the detention center confirmed that Stanziano was, in fact, released that same day. In Greene County, Conroy DeLuce, LEX 18 News.
Unbelievable. Posted on social media. Our 13th juror comment of the day comes from Ed, who says and asks, is it illegal? I don't know. Ethical problems, yes. Legal bar problems, yes. Well, this is one I didn't even know what should or shouldn't be done or could or couldn't be done. Let's bring back in the think tank, Michael Sterling and Bremner Rick King. And I'll start with you. Your thoughts about, is this even illegal?
For her to be under the influence in court?
Yes, yes, lawyering under the influence, LUI.
I don't know if that'd be an interesting crime, but the fact is the judge has the inherent contempt powers and the power to control his courtroom and to ensure that the defendant gets a fair trial by a lawyer who's not under the influence. So I think what he did was appropriate, and he exercised contempt by jailing her when she refused to take the test. What I'm wondering is, what were the results of the test? We don't even know. And I'm like, why? She's in a wheelchair. I mean, I feel sorry for her. On the other hand, I feel more sorry for her client if indeed that case is going to go forward with her impaired, as she appeared to be to the judge.
So I looked up the rules because I needed to know. I understand the obvious, direct criminal contempt allegation the judge made and his obvious need to control the judicial administration of his courtroom. I get that. But when you look at the rules don't provide that type of relief. What they say the judge is supposed to do is he's supposed to he could talk to that person's supervisor if they're a public defender. He can make a bar complaint. He could try to get the rules are actually more designed to get that person some help rather than to throw them in jail. So I don't know if that was the appropriate response at that time. Can he do it? Sure. Should he do it? Probably not.
Yeah, Vinny, I think that outside of the contempt rules, which give the judge broad discretion over his courtroom, I don't think there's anything necessarily illegal about it. And I think that, trial judges have been a little harsher on this. Appeals judges who don't have to actually see the lawyers in front of them have been a little bit more lenient. For example, Robert Wayne Hosley, who was convicted and sentenced to death in Georgia, his attorney admitted to having a quart of vodka, the equivalent of 21 shots a night, before handling his death penalty trial. In Haney v. State, the trial lawyer in Alabama showed up so drunk that the judge sent them to jail to dry out and then continued the trial the next day. They were later sentenced to death. So the client was later sentenced to death. So, trial judges have tried to get some control over this. Lawyers, unfortunately, Vinny, because of our profession, are almost 3 times more likely to consume alcohol or to fall victim to alcoholism because of the tremendous stress, as you can imagine, Vinny. You know this, Rick knows this, Ann knows this. Because of everything we deal with on a day-to-day basis, unfortunately, lawyers have a much more higher susceptibility to falling victim of alcoholism than the general population.
Yeah, it's one of the reasons on the other side here, and I got out. You all are still trapped there, day to day. I'm on the other side, away from some of that stress. And the thing that surprised me here, and we have about 20 seconds or so, is that the judge said, take the test or go to jail. I was shocked about that. I can understand, you're not going to take the test, all right, then we're going to do something here, but take the test or go to jail.
He meant business. I mean, basically that's what he did, and he put her in jail, and then she took the test. So mission accomplished, I guess. But yeah, very surprising.
All right.
That's where I have the problem too.
I don't know a defense lawyer that's going to comply. Like, what defense lawyer do you know that's going to comply? Like, I don't know one. Yeah.
True. Right.
Yeah, and at the end of the day, we want sober attorneys representing defendants because everything is at stake. And at the other hand, we also want lawyers to get help if and when they need it, and it looks like that was needed here. What a great job tonight, Michael Sterling, Ann Bremner, and Rick King. Always great to have you on here. We appreciate it. Thanks so much. We'll see you again real soon.
Thank you.